Now, basically, let's look at the general principles. The general principles under international law. They are stipulated under Article 33 of ICJ Statute. The general principles, being that they are general, they must be relevant to international relations, and they must be necessary for dispute resolution. So one, we have the general principle, so-called the principle of good faith, or pacta sunt servanda. Pacta sunt servanda means that the case must act honestly and must respect the agreement. So the moment you enter into an agreement and make a treaty, then it means that you have to follow and make sure you reach the requirements of the agreement. An example is the agreement made by the United States and Iran, but we are seeing some implication that Iran and United States, they are disobeying the terms of the agreement. If it is to follow the ceasefire, and tomorrow you wake up in the morning, you are exchanging missiles, to fight, then it means the general principle of good faith is not followed well. Now, here the principle of good faith, the agreement made by parties must be followed honestly. We have the case of, you go read the case of Austria versus France. Austria versus France. Now we have another principle, estoppel. A state cannot go back and oppose the already made agreement. If you're to follow the general principle of good faith, then why are you opposing the argument you made? That's what I've said. Now, the United States and Iran have decided to say that let be a ceasefire. Let this happen. Let us do this. Let us do this. But you're saying, or you're opposing, or you're denying what already said, or what already agreed. We have the case of Cambodia versus Thailand. Thailand had accepted a map showing the temple in Cambodia, but they went ahead to disagree or to deny. The court held that Thailand could not later deny it. Yes. We have another principle of res judicata matters already decided. The dispute had been resolved, but you are again bringing the same case for the dispute to be resolved. So here, the principle says that it can't be tried again when a dispute has been properly decided by a competent court or a tribunal between the same parties. Then it must not be brought back to be tried again. We have the case of Bosnia and Herzegovina versus Serbia and Montenegro. So in this case, the court emphasized that what has been finally decided must remain settled between the parties. If Council F sues B over border dispute and the Court of Justice gives a final ruling, then Council B cannot later bring the same claim over the same. We have another principle, equality, or the fairness. The court must apply what we call fairness when applying the law, because the court must look neutral. But we still have the problem. An example is the the ICC and the ICJ. Who are the founders of the same? You'll find these United Nations and United States, and you'll find there are certain countries who has uh, that court may apply fairness when strict law is neutral. We have the case of North Sea continental shift case. The court used equitable principles to divide continental shift boundaries fairly. So they tell us that the court making the decision must be equal and neutral. How much we can see some incidences, we can see some examples where courts, international courts, are being funded by some states, but we presume that they go ahead and they give that equal treatment of nations. Another principle, we have the responsibility for wrong acts. The country must be responsible to pay for the wrong act made. An example is the Uganda versus Congo, the under ICJ in 2005. They ruled against Uganda to pay for the unlawful act made to Congo, and Uganda were liable, and they started paying all they did what they were told to do. That is Uganda versus Congo, had happened in the ICJ 2005, and we are seeing that Uganda was responsible for that, for the unlawful acts that they did, and this is stipulated under Article 2.4 of UN Charter. Where you find that where there is an unlawful use of force to do things, then you can be held responsible. Another example is the case, the reason why I'm using the case of basically the example of Iran and the United States, because it is the recent, you all know the war. Being that the United States started the war and went ahead destroying the infrastructure of Iran. Do you know that the United States paid some money to Iran for damages? Do you know that? Thank you for watching. Thank you for listening. Brighton, my name is the Barrister. We meet in another video. I salute you all.